Hello everyone, welcome to the SIAC India webinar on the topic choice of a foreign seat by Indian parties, rationale, advantages and learnings. Thank you for taking out the time to join us for today's webinar, which will involve discussions around the recent landmark decision of the Indian Supreme Court on the issue of selection of a foreign seat by two Indian parties. We're delighted to be joined by leading arbitration practitioners as panelists for today's webinar. Mr. Dhyan Chinnappa, Senior Advocate and Additional Advocate General, Ms. Shaneen Parikh, Member of the SIAC Court of Arbitration and Head of International Arbitration at Cyril Amarchand Mangaldas, Mr. Nitesh Jain, Partner at Trilegal, Mr. Nandakumar Punya, Principal at Baker McKenzie, Vaughan Law, Mr. Tom Furlong, Partner at Herbert Smith Freehills. The session will be moderated by Mr. Nicholas Peacock, Partner at Bird & Bird. Please post in your questions on the Q&A function on the Zoom screen. Over to you, Nick.
Thank you, Shweta. Thank you, everyone, for joining us. Thank you to SIAC for putting on this event on what is indeed a landmark decision from the Indian Supreme Court, and one that any practitioner who deals with arbitration related to India should and needs to know about. And we've got a very fine panel to discuss it today, to tell you what it's all about, and also to talk more about the implications of it. As Shweta mentioned, we'd like your questions too as we go along. Post them in the Q&A, and let me warn you as well, there's a poll coming. We'll be asking a question for your votes a little way into the session, and then we'll see what the views are of you, the viewing public, on this. So it's a decision of the Supreme Court. It's of interest, of course, for practitioners in India practicing Indian law, but I think it's also of international significance for anyone doing India-related disputes. Very often, as practitioners will know, tax and other concerns mean that international parties will conduct business inside India using local subsidiaries. And of course, with the vibrant Indian economy we've seen over the last decade or so, notwithstanding current difficulties, there's an increasing amount of outbound trade from India, export from local companies. So this is not a domestic question. This is very much an international question that we need to know about. Now, long-time viewers and participants in the Indian arbitration scene will know that the seat of arbitration and the permissible seats of arbitration under Indian law and what that means for the process has been not always a straightforward question when looked at under the guise of the Arbitration and Conciliation Act 1996. We've had interesting and vexed issues to deal with both in cases and in drafting arbitration clauses, whether Indian courts would or could claim supervisory jurisdiction over arbitrations taking place outside India. That was an issue in the past. Whether if you seated your arbitration outside India, you had access to the Indian courts for interim relief, which of course is a very significant issue if the subject matter of the dispute that's being arbitrated in, say, Singapore or London is actually inside India. And of course, the important question of whether two Indian parties could choose an overseas seat for their arbitration, and a related question which was tied into it as to what governing law they could choose. Well, we have a decision now. I think it's part of a positive trend of case law coming out of the Indian Supreme Court supporting international arbitration. This one's authored by Justice Rohinton Nariman. It's 106 pages of quality prose. It's forceful and it's clear, and I think it's to be welcomed. So let's get on and try and explain the significance of it to you. I'm going to turn first to Dhyan, if I may. Could you set the scene for us and explain to us the background to this judgment and where Indian law stood as the Supreme Court considered this case?
Thank you, Nick. Thank you, SIAC, for inviting me to be part of this panel. It's indeed a pleasure to be part of this august panel of speakers today. I think the participants will have a lot to benefit from this panel. Let me actually start with some trivia. This whole concept of inherent jurisdiction, of jurisdiction in a particular place where the parties reside, cause of action arises. This actually has, as I was told by an English judge a long time back, some history, English law history actually. And I'm told that in the 17th century, judges were actually paid by the parties to decide cases in various parts of the United Kingdom. or maybe it could be the 16th century as well. And then there was a danger of work going away from the judges to other judges who might be a little more inexpensive. So the concept of inherent jurisdiction was invented, so that you must have inherent jurisdiction to actually make a decision. And therefore you ensure that work which is local to yourself remains within yourself. Well, Indian law accepts it entirely. Indian law can't get beyond that and hasn't gotten beyond that for a very long time, which is why we have recognized that if you have a choice of court clause, you must ensure that the court actually has jurisdiction. You can't go to a court which doesn't have jurisdiction. It's of course now in arbitration being breached. Breached, according to me, quite contrary to Section 2E of the Arbitration and Conciliation Act, which defines court. Supreme Court says, however, if the place of arbitration is different from the court which has jurisdiction otherwise, the courts which have jurisdiction over the place where the arbitration is conducted would be the proper court, and you can approach that court. How it has arrived at is another issue, not a subject matter of discussion today, but that it does seem to be contrary to the definition of court in the Arbitration and Conciliation Act. Now, insofar as the question of whether two Indian parties, Indian entirely, can choose a foreign seat, interestingly was subject matter of question before the Karnataka High Court in the year 1998. It wasn't on an arbitration issue at all. And this is a judgment which somehow has missed everybody's attention. It was actually in a public interest litigation where there was a challenge to a contract that the state of Karnataka had entered into for development of a highway. And the state of Karnataka had agreed to arbitrate in London under English law. So in a public interest litigation, this contract was challenged. And one of the contentions urged was that an Indian government or a state government cannot opt out of Indian law and cannot agree to jurisdiction outside India to arbitrate. Interestingly, the Karnataka High Court in 1998 analyzed the 1996 Arbitration and Conciliation Act and came to the conclusion that there is absolutely nothing wrong in choosing a foreign law or having a place of arbitration outside India for a state party. This, of course, has missed everyone's attention. It did go to the Supreme Court. Leave to appeal was rejected. And therefore, this actually constitutes the first judgment on this principle. The next, actually, interestingly, was a case called TDM Infrastructure versus UE Development India, a matter which I had argued for UE development and succeeded, interestingly, on a whim. We actually raised this just for the sake of opposing appointment of an arbitrator by the Supreme Court. And the real question there was very simple. There were two subsidiaries in India of two Malaysian companies. The question was, is it an international commercial arbitration or a domestic arbitration? We argued that it was domestic, and that because the law provided for central management and control at that point in time being outside India, that is amended today. But we argued it quite differently, and we said, well, they are Indian parties, they can't contract out of Indian law, and therefore they can't have, and therefore it can't constitute an international commercial arbitration within India. Let's understand this. The place of arbitration in that case was India. And therefore, Section 28 of the Arbitration and Conciliation Act applied. Why I'm pointing this out is because afterwards, this judgment has been completely misunderstood. It's people have understood it as meaning that Indian parties can never contract out of Indian law, which is why the Bombay High Court in Aadhar holds that, two Indian parties can never contract out of Indian law, and therefore, applying TDM, they ensure that the arbitration remains in India and did not go out to Singapore. That is one case which seems to be completely wrongly decided on a misunderstanding of TDM infrastructure. The other judgment, of course, which didn't answer this question was Sasan Exports, which was decided in the Madhya Pradesh High Court. And there it was held on an interpretation of 28, place of arbitration, and whether in a particular, whether if a place of arbitration is outside India, you could have a law which governing the contract or the arbitration also being other than Indian law, and upheld it. But when the matter went to the Supreme Court, both parties didn't argue it. And therefore that question was not answered. So that remained unanswered in that case. Of course, there was another judgment called Atlas. Atlas was under the Foreign Awards Recognition and Enforcement Act 1961, which was really the law that existed at that point in time to enforce New York Convention awards. And there the question arose as to whether a place of arbitration outside India would violate Section 28 of the Contract Act. Now, Section 28 of the Contract Act declares contracts unenforceable, which bars a party from approaching the regular legal courts in India. The exception to Section 28 is that if it's arbitration, the main provision would not apply. The Supreme Court interpreted that and said, the proviso to Section 28 does not bar arbitration outside India, and therefore it is not violative of, therefore arbitration outside India does not violate Section 28, and therefore really doesn't violate public policy of India. All of this existed, and then of course, I think in PASL versus GE, the arbitral tribunal was led quite significantly by another judgment known as Reliance Industries versus Union of India, which actually did not answer this question at all. And Reliance Industries was on the question of whether pre-Balco, that is when Bhatia International was overruled, whether in a scenario of that kind and where the place of arbitration is in England and the governing law is Indian law and the law applicable to the arbitration is English law, whether an application under Section 34 to set aside an arbitral award would lie. And that was the question which was really answered in that case. Therefore, I found that the reliance by the arbitral tribunal in PASL's case on Reliance Industries as being the leading authority on the subject may not have been entirely apposite, although it did lay down that you could have a different governing law, a different law governing the arbitration, and a third law governing the reference. But having said this, I think the stage was set for the Supreme Court to answer this question rather authoritatively, which it did. And according to me, although there were several arguments advanced, all those arguments have been put an end to, making it absolutely clear today that two Indian parties can arbitrate outside India. And if they do arbitrate outside India, they could have the governing law of the contract as anything other than Indian law as well. And that is very significant for Indian parties, well, you see, if you look at the judgment, whether it's correct as a matter of Indian law, I think it's absolutely right. Whether it's correct as a matter of policy, well, that, of course, could be debatable. And therefore, I think this is the background, and this is where we must start analyzing PASL. Thank you, Nick.
Thank you, Deanne. We'll come on to policy, I think, later on, and we'll talk about what we think might be the reaction to this decision. We have a question in the Q&A box already to ask the name of the judgment delivered by the Karnataka High Court, if you're able to tick that off now.
I'll put that out.
Wonderful. Thank you very much. Right. Well, look, there's the background. Let's get into the case. I think it was somewhat murky. I think Deanne's done perhaps a deceptive job of making it sound straightforward and clear before we got to this case, which it might have been for him. But I think those watchers outside India were a little bit more confused. I was one of the interested watchers in relation to the Sasan case, myself and a tribunal that had been constituted in London waiting for that decision to be made. And certainly the judgments of the appeal bench and the Supreme Court brought some clarity, but not absolute clarity. So let's look at this decision, the PASL decision. Shaneen, you were involved in the case. You have special insights, not to speak of your extreme knowledge. Why don't you tell us what were the issues in the case and what did the Supreme Court go ahead and decide?
Yeah, thanks, Nick. Thanks, SIAC, and thank you everyone for being here. A fun fact actually is that we took a contrary position in the arbitration. And the arbitration actually emanated out of disputes that arose under a settlement agreement. And that settlement agreement itself arose out of settled disputes under another underlying agreement. The parties were PASL and GE Power, which was an Indian subsidiary of the GE Group, which is relevant from the point of view of considering why really would they have opted for perhaps a foreign seat. The settlement agreement provided for resolution of disputes by arbitration in Zurich, and there was no provision for governing law. But during the course of the arbitration, both parties agreed that Indian law would apply. Now, PASL invoked arbitration in 2017, claiming damages of about 175 million US dollars from GE for various claims related to breach of warranty. GE did not have a counterclaim, so we were only defending this claim against us. And therefore, as a strategic decision, we took as a preliminary issue the fact, or we argued that two Indian parties could not arbitrate in a foreign seat. And that was really interesting because we had to struggle very hard to argue this point, because I don't think any of us really believed that this was the correct position. There is no preclusion in the Act against a foreign seat. If at all, Section 28 only refers to substantive foreign law. But anyway, happily, by way of a procedural order, although we asked the arbitrator to pass it as an award, he passed a procedural order ruling that there was no preclusion to a foreign seat, either under Swiss law, which was the curial law in the arbitration, or under Indian law. And when we succeeded in the arbitration, what we're really enforcing today is therefore only a costs award of about 400,000 US dollars. So I think we're also lucky that we were able to file an application for enforcement for this costs award, because it may otherwise not have reached the Supreme Court so quickly, and definitely not have come up before the absolutely brilliant Justice Nariman, before whom we were very keen to come up and really push the matter. And another fun fact is that this was decided in a matter of 3 months. So in the Supreme Court from the time of filing the petition. Now, in the ruling, Justice Nariman answered the question of whether is there really a preclusion in the Act against an arbitration involving only Indian parties opting for a foreign seat. Is such a contract violative of the public policy of India? And what is the extent of party autonomy, which is really one of the mainstays in arbitration? Now, all of these were answered in the SLP. Sorry, just to step back one point, the SLP arose out of our application for enforcement in the Gujarat court. So we had an application for enforcement of the cost awards in the Gujarat High Court, and PASL, doing a complete turnaround of its position, filed an application to challenge the award in the Gujarat District Court, which was then moved to the Commercial Court. So we had these two parallel proceedings going on. The Section 34 petition, if we did not have an application for enforcement, I think we'd still have been struggling in the set-aside application. So these facts were actually quite fortuitous to getting us here. The Gujarat High Court ruled that the award was a valid foreign award and it was enforceable as a decree of the court, which was challenged by PASL in the Supreme Court. GE had filed an application for interim relief in support of the enforcement application. And on that, the Gujarat High Court ruled that that was not permissible. Maybe I will deal with that, or we can come to that a little later. But we took the opportunity to make cross objections on that part of the ruling in the Supreme Court. So that issue was also decided. Now, the Supreme Court decision, I think, now conclusively rules that two Indian parties can choose a foreign seat of arbitration, and that such agreement will not adversely impact the parties' ability to seek interim relief before Indian courts. The first first important thing that Justice Nariman acknowledged or clarified was the critical role of party autonomy in arbitration, obviously because it is a voluntary dispute resolution mechanism. And it referred back to its earlier decision in Bhatia International to refer to party autonomy as the brooding and guiding spirit of arbitration. And in ruling on the fact that a foreign seat was permissible, it ruled that nothing stands in the way of party autonomy in designating a seat of arbitration outside India, even when both parties happen to be Indian nationals. Now, in terms of international commercial arbitration and the import of that and enforceability of a foreign award, the Supreme Court, and I think this part of the judgment is something that might be relied upon by several courts going forward. It noted the difference between enforceability under the New York Convention, which is in Part 2, Chapter 1 of our Act, and the older Geneva Protocol and Convention. And the court ruled that in ascertaining whether an award was a foreign award enforceable under Part 2 of the Act, i.e., whether it was a foreign award that complied with the conditions under the New York Convention, it ruled that it was only the territoriality principle that applied, and that the New York Convention was party neutral. And that is the difference between the New York Convention and the Geneva Convention, where the Geneva Convention required territoriality, i.e. the award being made in a reciprocating territory or seat of arbitration, and also that the parties to that award were nationals of that territory. And therefore he distinguished it to say that the fact that parties were both Indian companies was irrelevant, because it was only territoriality or a foreign seat that had to be looked at. And therefore, this would not make an award passed in a foreign seated arbitration a domestic award, which is what PASL was trying to argue. It would be a foreign award and enforceable by an Indian court, subject, of course, to whatever challenges there were under the New York Convention. Touching upon the point of policy that Dhyan was talking about, insofar as the concept of public policy stands today, PASL had, of course, argued that permitting parties to designate a foreign seat amounts to contracting out of Indian law, which is not permissible. And that argument was expressly rejected. And the court held, and I will quote, that the balancing act between freedom of contract and clear and undeniable harm to the public must be resolved in favor of freedom of contract, as there is no clear and undeniable harm caused to the public in permitting two Indian nationals to avail of a challenge procedure of a foreign country when, after a foreign award passes muster under that procedure, its enforcement can be resisted in India. And while so ruling, interestingly, India, whose government seems to be quite conservative, obviously isn't as conservative as we thought, because countries such as the USA and China have specific legislative prescription against their nationals or domestic parties arbitrating in a foreign seat. And this was also noted by the Supreme Court to rule that therefore it is permitted. And while so ruling on the foreign seat, it also overruled the two earlier decisions, and I think Dhyan mentioned Aadhaar Mercantile and Seven Islands, which had ruled that a foreign seat was contrary to public policy. Two other issues of having a second bite at the cherry and interim relief, I think I'll hold on to and let Nick get to it later.
Yeah, thank you, Shaneen. We'll come back to those because they are both interesting points from the judgment, and I think it's important that we clarify them. Why do you think you said it got to a decision in 3 months? Why did the Supreme Court take this case so quickly, do you think?
I think it was a couple of things. We kept pushing. We had pushed. In fact, again, another fun fact. The other side dragged its feet in actually, it portended this great challenge to the Supreme Court, but really dragged its feet in actually going there to, our Indian defendants can sometimes be quite clever in prolonging things. So we kept pushing in the High Court. We brought up this fact before the Supreme Court that matters had been prolonged. But I think really what it was our luck in getting Justice Nariman, who, has been laying down, it's impossible to keep track, judgment after judgment in clarifying or setting the law in India. He retires in August this year. And I think he was also very keen on hearing the issue. And as we approach the summer vacations, he just wanted to get it done in April. So I think the stars aligned for us in this one.
Great. Well, hats off to Justice Nariman, and certainly his energy will be missed from the bench when he retires. Absolutely. One might say far too soon. Good. Well, look, let's then get a bit of a reaction to this. And I'm going to turn to Nitesh first. For review, please, from within India, of what the significance of this decision is from your perspective and what you think it might mean going forward.
Thanks, Nick. Good afternoon, everyone. Hope everyone is keeping safe. And thank you, SIAC, for this opportunity. Indeed, it's yet another judgment, very crucial one by the Indian Supreme Court, and I'm very glad that we are discussing it today. Talking about the impact from the Indian perspective, right? Now, whether this judgment will impact on promoting India as a seat of arbitration, probably we should discuss that later. But the impact is certainly to provide clarity, right? And once again, reiterate India's commitment towards the growth of arbitration-friendly jurisdiction, and recognize party autonomy. These are very, very important, right? We all know that, see, the Indian arbitration law has been very, very progressive. And it's evolving. And the present judgment is actually a classic example to support this. Indian arbitration law is mostly a court-made law, but it's also been recognized by the government, and therefore both legislature as well as the judiciary, they both have contributed in terms of the development of the Indian arbitration law, apart from, of course, the practitioners, the institutions, and the arbitrator. Impact from the Indian perspective, of course, we all have discussed how there is clarity on two Indian parties, choosing arbitration seat outside India. What this also explain is the relationship between the Part 1 and Part 2 of the Indian Arbitration Act. In India, we just have one Arbitration Act, right? The Supreme Court has clearly said that Part 1, of course, is very wide. It talks about conduct of the arbitration, challenge, enforcement, everything. Part 2 is limited in terms of its applicability, which is in relation to the enforcement. And do not read Part 1 into Part 2, because that's the basis, by which the court has actually answered. And therefore, in terms of policy or legislation, doing anything around with this judgment may be difficult, because that's how the court has read this, right? When I see this judgment from Indian perspective, this is very significant for companies which are based in India, and they've got foreign parent companies or international presence, and they want to have neutral seat, right? Because when we used to advise, we used to say, okay, let's have a foreign party or an international party in this agreement, right? So that the arbitration becomes an international commercial arbitration, and we can have seat, let's say, in Paris, London, and Singapore. That's the practical solution we had. I don't think we need to just, we can easily avoid that. Two Indian parties who are material to a contract can certainly do it. So what's really relevant, and I think, Nick, we will be discussing this question later also, is that, why are we even discussing this situation, right? Why is that two Indian parties are actually choosing seat outside India? You can very well do arbitration in India, right? But what is the necessity of doing it? There are various answers to this, which I think, so let me just, try to see, give my perspective. One major factor is that they want to do arbitration by institutions, right, which are well recognized and administered. India still continues to be ad hoc driven arbitration jurisdiction. So that is one major factor. Speedy arbitration, but a response to that has been given by the Indian Arbitration Act. We have strict timelines and we are actually adhering to those. We are finishing arbitrations in those timelines. There is a speedy recourse to the court in the country outside India, right? Where you are challenging or setting aside. But even the Indian Arbitration Act has made several changes to 34 and 36, which is in terms of setting aside and enforcement. Now, there is no longer an automatic stay. There is a timeline. You can move execution parallel. So I think these two factors have been taken care as far as the Indian Arbitration Act is concerned. The biggest advantage that I see is to avoid complete challenge before the Indian court, which is under 34 and 37. Now, there are various grounds on which the arbitration award can be challenged, which is under section 34. Of course, now the cases have decided that there is very, very limited scope. We have section 34(2)(a), which introduces the ground of patent illegality, which is applicable only to domestic, not to international commercial. So therefore, two Indian parties doing arbitration in India, that ground will be available. So at times, the thought process is, can we avoid the Indian courts? Absolutely. Of course, the answer is yes. You can now choose, let's say Singapore as the seat of arbitration. Your 34, 37, appeal to Supreme Court, everything goes. You get a quick arbitration award. You may want to challenge, may not want to challenge. The winning party can come under part 2, simply go and seek speedy executions. There have been a lot of cases by high courts and Supreme Courts that the court will not interfere in the execution of a foreign award. So, I mean, it becomes a very win-win situation for party who's actually won the arbitration, right? Under the English Arbitration Act, I mean, I can recall there is this section 69, which provides that on a point of law, the parties can actually can exclude that appeal before the English court. So by choosing arbitration outside India, I mean, it is sort of parties agreeing to exclude the challenge completely as far as India is concerned. So under 34, there are various grounds, including patent illegality, that can certainly be excluded. Now, one of the biggest disadvantages that I see, and that disadvantage is only because of the various improvements made in legislation and because of various judgments, is because so when you are doing arbitration outside India, you will have to challenge that before the court of seat, right? Now, you may not in terms of what the grounds are. They may be wide, they may be more narrow, they may have different interpretations. So that is one risk that you're taking. Second is, of course, when you come back to India, you still have to face resistance on the challenge, right? Which is more or less similar grounds as of 34. And of course, the panel can discuss later in terms of 1 bite, 2 bites at the cherry, right? Because this is how the context will come in. In relation to impact of this judgment on whether the Indian parties can actually choose foreign law, I don't want to, and maybe the panel can debate that more, because this is a very, very interesting issue, and maybe we'll have another case to decide and another webinar to discuss that. But I think, as Shani rightly mentioned, I think the parties agree that Indian law will be the law governing the contract, and that's the reason Supreme Court did not want to venture into it. But Supreme Court, I think, has rightly said in one of the paras 98 to say that the conflict of law rules and section 48 of the enforcement of an award, which is the provision, already takes care of this situation. So I think the Supreme Court has hinted that, I mean, not in as many words, that you can certainly have foreign law. And if the intent is to circumvent the fundamental policy of the Indian law or the mandatory provisions of Indian law, then of course the Arbitration Act itself takes care of that situation. Now, on the side of this judgment, there was another judgment last month that came from Supreme Court. Very, very important, not in context of arbitration, but in context of execution, which I should mention here. The Supreme Court has said that all the execution must be disposed of within 6 months. That's very, very important, because even if you get a foreign award, you can straight away come to India, seek execution. The Supreme Court said you should do it within 6 months. And if there's a delay, please record that in writing. The Supreme Court interestingly passed directions to all the high courts in India to reconsider and update all the rules in relation to the execution. So this is a very, very important development as far as the execution is concerned. Section 34, the timeline also becomes important here. the challenge under 34 for a domestic award in India is, of course, 3 months. But there have been a lot of provisions that have been enacted, especially in relation to 36. So even if there is a challenge, you can still go in for enforcement. And there is no automatic stay just because you have filed 34, unless the court gives a stay, and court can impose various conditions. And we have seen this practically playing it out. A lot of settlements, they happen at this stage. So before I conclude, just coming back to the question, which whether this judgment will have any impact on promoting India as the seat of the arbitration. This judgment was in background of 2 Indian parties doing arbitration outside India. So we shouldn't see this in relation to promoting India as the seat of arbitration, but what we should certainly see is that this judgment certainly promotes India as an arbitration-friendly jurisdiction. That's very, very important, because we have seen how the arbitration law has developed in this country. Secondly, I very strongly believe, and of course the panel can discuss that this judgment will actually promote the institutional arbitrations in India, because that is one of the key factors. Apart from excluding the Indian court jurisdiction, the parties actually want to have good, well-recognized institution. So these are broadly my thought on the impact of the judgment. Thank you, Nick.
Great, thank you, Nitesh. And just one word of caution, I guess, when we talk about overseas courts having speedy recourse to courts, not all courts are speedy. Of course, those in Singapore and London are definitely speedy, but do be cautious, I think, in choosing a seat outside India, that you know what the environment for arbitration and court support is there. Well, look, I'm going to turn now. Kumar and Tom have been sitting very patiently, and we're going to get a view from outside India. First, I'm just going to tee up our poll question, please, for you, the viewers, because we've set the scene now. We've discussed this decision, at least from an Indian perspective. We're going to come back to talk a little bit more about it on public policy and whether we think it's good or bad. But let me ask you that poll question as well, please. Is the decision in PASL good for the future of India as a seat of international arbitration? We've said it as nice black or white question. There's no nuance in a poll, as we know from Brexit. So let's have your views on that, please, and we'll report back on that at the end of the session. Meanwhile, Kumar, thank you for waiting. Let me turn to you, please. You're based in Singapore. What's the perspective there? And what do you think the likely impact of this decision is on parties choosing Singapore as a seat of arbitration for India-related disputes?
Thanks very much, Nick. I've thoroughly enjoyed the discourse so far. So I have to thank SIAC for allowing me to be a part of this. We've been taken from inherent jurisdiction in the 16th century to fun facts in April 2021. So thoroughly enjoyed it. So in answer to your question, Nick, I think the most obvious impact is that Singapore will be even more popular as a seat of arbitration for Indian parties. I think if you look at the statistics coming out from SIAC, Indian parties have historically been the top users of arbitration in Singapore. This is only going to basically improve that, I think, enhance the popularity of Singapore as a seat. But just taking a step backwards, I think if I were an Indian party, I wouldn't rush off to stipulate Singapore as a seat of arbitration. There are still important differences between the arbitration law in Singapore and the arbitration law in India on concepts such as arbitrability and public policy, just to name a couple. Just on arbitrability, for instance, under Indian law, as I understand it, minority oppression disputes are not arbitrable. Right? It goes to the NCLT in India. In Singapore, they are seen to be arbitrable. So where you have 2 Indian shareholders coming together in a shareholders agreement and agreeing to arbitrate that in Singapore, right, where there are issues of minority oppression, that would be arbitrable under Singapore law. But under Indian law, they have to go to the NCLT. So that becomes a live issue. So parties still do need to consider, whether there are consequences and implications if they were to pick a seat outside of India for their arbitration, 2 Indian parties, for instance. And on public policy, we've already touched on it, I think. Again, the manner in which the courts in Singapore approach public policy is quite different from that of the Indian courts. Whether the public policy of Singapore is engaged in perhaps a setting aside application is quite a different question when compared to whether the public policy of the courts of India is engaged when you are considering enforcement. I mean, Nitesh has already mentioned issues of circumventing Indian law, that would perhaps engage the public policy considerations when you're before the Indian court, and it may not be so when you're before the Singapore court. So these are issues, live issues that I think parties need to consider before they stipulate Singapore as a seat. But on the whole, I think what will happen is that Indian parties, particularly where Indian subsidiaries are involved of foreign incorporated companies, it's more likely that they will pick Singapore or London or a foreign seat to arbitrate their disputes.
Thank you. Excellent. Some good initial thoughts there. And I think just a bit of clarity for those who are perhaps less familiar with the arbitral process. What's going to happen if you choose, say, London as a seat of arbitration, is that the challenge to try and set aside an award, if you disagree with it on sufficient basis that you think you've got grounds to set aside, that will happen in English courts under the English Arbitration Act, the standards there. Then if you want to try and enforce it in India, you will bring it into India, where of course it will go before the Indian courts under Section 48. And then there will be grounds to resist challenge, one of which will be public policy, if it offends the public policy of India, and we'll come on to that. Tom, let me turn to you now, please. Another international perspective. English lawyer, you're based in Singapore now, you previously spent time in Hong Kong. What's your view of the perspective of international parties here? How do you think this judgment will be viewed by them and might impact their behaviour?
Thanks, Nick. So, to me, it seems this judgment is a really big deal and a big reassurance for foreign parties doing business in India. As you said at the beginning, there are lots of good reasons why foreign parties often incorporate subsidiaries in India to do business, whether that's related to tax or foreign exchange control, or for some sectors where you just have to work through a local subsidiary if you want to, for example, take a concession in the renewables sector. And so foreign parties are often operating through local subsidiaries. And until now, when negotiating the seat of arbitration in a contract, an international party would often, through their subsidiary, would often be met with the argument that actually you can't choose an offshore seat. And then our client would sort of come to us and ask us, well, is that right? And often they would have heard from the local counterparty that there was a lot of uncertainty under Indian law, particularly around the TDM infrastructure line of cases. And we'd have to accept that, yes, that's right, there was a lot of uncertainty. I think I was in the same camp that you were, Nick, that this wasn't a clear-cut issue at all. And that's important because you have to remember the perspective of parties when drafting arbitration clauses is they tend to be very risk adverse. You know, no one wants to be the person who drafted an arbitration clause that ends up not being enforceable. And so where there was uncertainty, that was really driving parties to choose India seats. You know, some parties were willing to take the risk before. You know, there was some basis for that in Indian law, but I would say on the whole, the sort of more risk-adverse approach won out. So putting all of that together with what we've heard so far, I think it's really important to look at not just the decision itself, which I think we all agree is the right decision, but also the clarity of the decision. Although there were some quite technical issues that had to be resolved, a lot of textual arguments to be addressed about the structure and the meaning of the language in the Act and of the other statutes, it's quite clear that this is not a decision about a technicality. You know, the repeated references to the importance of party autonomy and the rationale behind allowing Indian parties to choose offshore arbitration are all incredibly clear. The public policy arguments have all been addressed head on. And so I think the clarity of the judgment, as much as the outcome, will be what provides reassurance to foreign clients who are working through local subsidiaries. You know, so you hear the language in the judgment of the decks being cleared, and I think that's exactly right. It's a clear signal to foreign parties about what they should expect. I also, though, agree with everything that's been said about that this doesn't mean that foreign parties have an easy decision to make when thinking about how to deal with India-related contracts. And public policy is a really good example of that, because although, as we've been discussing, we can now arbitrate offshore, it's likely that in those cases, enforcement is still going to be onshore. And so unless you really understand how, for example, the Indian courts are going to apply public policy, it might not be much reassurance that the Singapore courts thought that it was fine, as we've been saying, to arbitrate a minority oppression claim, because when you come to the enforcement stage, you're going to be receiving a different answer. So I think the court probably went as far as it could to make the position clear for foreign parties, but it doesn't mean that all the questions have been answered by any means.
Great, thank you, Tom. And we've got some very good questions coming in on the Q&A, which we'll try and get to some of those in a moment, including on questions of enforcement. I want to first, though, go back to section 9. Perhaps I'll turn to you on this, Shanine, if I may, because we left that part of the judgment without comment, but I think it's important for parties to understand the significance of what the Supreme Court said on that point. So you have your arbitration seated in Singapore. Are you able to go to the Indian courts for interim relief in support of that arbitration, either as it's about to start ongoing or after the award? What did the Supreme Court say about that, Shanine, if you could help us?
Yeah. So the short answer to your question is yes, parties will still have recourse to Indian courts. But Tom referred to some technicalities, and I'm going to take the liberty of going into some of the technicality of that rationale. It comes from, first of all, a very pro-arbitration amendment that the government made, which allowed foreign parties to foreign-seated arbitration to take recourse to Indian courts under Section 9 and Section 27 of our Act for interim relief and court assistance in obtaining evidence. Now, the wording that has been used in allowing such parties to approach the court is the phrase international commercial arbitration. And the meaning of that phrase in Section 21F was amended post the TDM judgment to delete from its reference, or let me put it the other way. An international commercial arbitration requires, as one of the parties to that arbitration, being a foreign party. And therefore, the Gujarat High Court ruled that this being between two Indian parties, it was not an international commercial arbitration. And therefore, these two Indian parties would not have recourse to Indian courts if they chose a foreign seat. So keep in mind that it was still always, even insofar as the High Court was concerned, in an international commercial arbitration with a foreign seat that was possible. This ruling clarifies that even if it's not an ICA, it's a domestic arbitration, parties will be entitled to obtain relief. And what the Supreme Court then did was really distinguish between the phrases international commercial arbitration used at various places in the Act, because that phrase is also used when you're talking about enforcement of a foreign award. The court therefore ruled that when you're looking at the phrase international commercial arbitration in the context of a foreign award, that's why it went into the differentiation between the New York Convention and the Geneva Convention and the territoriality principle. So it's distinguished between the phrases in Part 1 of the Act and Part 2 for enforcement, and thereafter clarified that yes, notwithstanding their two domestic parties, they will still have recourse to Indian courts. So any foreign-seated arbitration parties have recourse to Indian courts for interim relief unless they have expressly agreed to the contrary.
Okay, wonderful. Thank you. That's a helpful clarification, I think, very significant. If two Indian parties do choose to take their arbitration offshore, it may well have an Indian subject matter. So, of course, access to the Indian courts and interim relief in support of that arbitration is a significant point. Let me take one of the questions from the Q&A, and perhaps, Diane, I'll throw this one at you. Once an arbitration is made by a foreign-seated arbitral tribunal, will it be easier to enforce it in India, do you think? If it's an overseas arbitration but between two Indian parties, will that somehow be viewed differently by the Indian courts on enforcement or not? What's your sense on that?
It's actually a good question. Of course, it depends on which side you appear for at that point in time in court. But to answer it fairly objectively, I think the answer is yes. The reason why I'm saying this is public policy by itself. was actually subject matter for judgment in Renu Sagar, an old judgment as to what public policy was. It then stood altered. Public policy, after all, is an unruly horse, like Lord Diplock said. So it really depends on the judge and what he considers as public policy of India. Though you have some principles which underlie it. You have the Supreme Court, which has then interpreted public policy in a variety of ways. But if you look at just the legislative framework, 34 is very different from 48, because 34 now lays down what is fundamental policy of Indian law or patent illegality. But if you look at 48, it does not. But typically how you've seen the Supreme Court looking at it is to give a lot of importance to how a foreign court has looked at the award. And if it has stood muster before a foreign court, then an Indian court would typically want to give effect to their award. I can give you an example. As a matter of fact, I had an arbitration in Singapore where there was an issue of limitation. And there was an answer on that question by an arbitrator. It was never challenged in Singapore, of course. But when it came to India, the only ground on which it is challenged and which is currently pending is on the question of whether the claim was within limitation. Now, limitation has been interpreted to be part of public policy of India. It's not answered as yet, but whenever it does get answered by the high courts here, you'll have an answer as to whether a court would be willing to look at the question of limitation again, since it is really, by Bombay High Court says at least, that it is public policy of India. So it's very difficult to actually put down and say it is going to be easy or difficult. It'll really depend on how one looks at the entire principle of public policy, because that is all there is to resist enforcement.
Great, thank you. Let me ask another question now. Perhaps Nitesh, I'll throw this one at you. We've asked on the poll whether this decision is good or bad for India's aspirations to be an arbitral hub, both frankly retaining arbitration from within its own economy and also attracting arbitration as a regional centre. And I guess, you've given a few thoughts on that. I think, like you, I see this as a very good judgment, which actually underlines India's growing maturity as an arbitral seat, and just the clarity with which the Supreme Court is increasingly bringing to the way it will treat and respect parties' choice of arbitration. But of course, you might also say this decision, by saying parties, you can go off to whatever other seat you want, Indian parties, it could lead to a number of parties deciding to take their arbitrations outside India, undermining domestic institutions, perhaps in the ad hoc market, and we could see a flight. People could vote with their feet. So in that sense, it could be pretty bad for Indian arbitration. So which side do you sit on? And if there is in fact an exodus, let's use dramatic terms, there will be, but if there was an exodus of Indian arbitrations to overseas seats, might the government look again at this? Might there be a legislative response to this decision, do you think?
Yeah, no, so Nick, that's very interesting. And I think it will be debated, right? At least in India, right? And I'm sure a lot of arbitrators in India will react to this situation the way you are saying. But the way I see this is, so the Supreme Court has not, so what the Supreme Court has done, Supreme Court has just given the clarity, right? Clarity in context of what part 1, part 2 are, right? There is, Supreme Court hasn't said that the intent of the legislature was not to allow the two Indian parties to do arbitration outside India. So the Supreme Court has not done any legislation, or the Supreme Court has not overturned any prevalent, the legislation to say that, sorry, the government was wrong, or this particular clause is wrong. Supreme Court has merely given an interpretation and a clarity on that point, right? So which means this situation was always there. And see, this is the essence of part 2, right? The New York Conventions, which is incorporated part 2, section 48, this is all seat centric, which is what the Supreme Court has said, and which is what the essence is, right? You take any country that has taken and that has incorporated New York Convention the way it is, right? With few changes, it is all around the seat situation, right? The place of arbitration. So what I'm trying to say is this situation was already there under the Indian Act. I don't think the government would want to change the situation, because this is what the legislation has already adopted. The Supreme Court has only clarified the situation. But to answer your question, of course, there will be debates, right? And this is where I say that the impact of the judgment is it promotes India as arbitration friendly jurisdiction, number one. Number two, it may promote institution arbitrations in India, because one of the factors why you go outside India is because you want to have well-recognized institutions. So the way I see this, of course, there will be a lot of arbitration outside India. Singapore is the favorite destination, right? London, Paris, there. But this should certainly promote institution arbitration, because see, you can have venues, in India, outside India, and given what's happening, the virtual mode, venue may not even be relevant, right? So by doing an arbitration, and you could have actually finished one arbitration during the pandemic, right? If you had started last year, you could have finished it this year. This seat could have been Singapore, and you would have been doing arbitration virtually.
Great, thank you for that. Okay, now let me turn to the topic of choice of substantive law. Deanne, perhaps I'll ask you to comment on that. I know it might be a bigger topic for another day, and it might be for another judgment to really clarify, but help us where we are now. I'm an unsophisticated overseas counsel. Can I choose a non-Indian law as the substantive law of the contract between two Indian parties if there are no other foreign parties in the contract? So it's just between Party A and Party B, both based in Gujarat. Can they choose a non-Indian law to govern their contract?
If you're doing the arbitration outside India, you can. If you're doing the arbitration in India, you can't.
And do you think then, if you had your arbitration outside India, but then brought the award into India to enforce, the fact that you'd chosen a non-Indian law would be a ground to resist enforcement?
No, it can't be. Because if you look at section 28, it opens with the words where the arbitration is held in India. And the bar of applying a foreign law when the place of arbitration is in India is only in India. And now PASL makes that certain, because no doubt it's a foreign award. But when it comes to India, you will apply, of course, Indian public policy to make a determination of the question as to whether the award is valid or not. And therefore, you must, of course, be certain that the award is valid in terms of public policy of India. But apart from that, really, I see absolutely no stumbling block in being able to enforce a foreign award between two Indian parties, having which has a choice of law, let's say, of English law as the law governing the contract. Absolutely none.
Great, thank you. Kumar, let me come back to you for a view on governing law. Oh, Shanine, you got your hand up. No, let's go to you. Go on, Shanine.
Sorry,
please.
Kumar. In theory, I agree with what Dhyan says. I think he's referring to section 28, which only says that where the arbitration is between Indian parties and seated in India, Indian substantive law will apply, and it doesn't go, there is no prescription against foreign law. But I think a lot depends on which court the award is brought for enforcement, where I think we will have very real issues of whether contracting out of Indian law as a whole is against public policy. And I differentiate that slightly between the contract itself having been opposed to public policy. So just the fact of whether two Indian parties can contract out of Indian law. And both in Balco and TDM, they seem to suggest that Indian parties cannot do so. In this judgment, I think Justice Rohinton Nariman very specifically stayed away from this point, because this is something that I think could persuade the government to legislate on foreign law, substantive law, and it may not on foreign seat. So I don't disagree with what Dhyan is saying in principle, but I certainly would think it was something very risky, and it is not something that I would necessarily advise, or I would request clients to keep their eyes wide open while providing for that. Sorry, I just wanted to clarify.
Yeah, maybe Nick, since you are coming to me, can I just add?
Yes.
Can I just add to that? I think one of the issues that, perhaps it's in one of the questions as well, and it's something that I touched on when I spoke about minority oppression. If you have a shareholders agreement between two Indian parties, two Indian individuals, right, in relation to a company, and you say that it's governed by Singapore law, seated in Singapore, right? So it comes to Singapore, and under Singapore law, it would be, if there is a dispute that perhaps pertains to minority oppression, it is arbitrable, right? So it would then be arbitrated, and there would then be an award, right? When you take that award back to India, you know, under Indian law, minority oppression disputes are non-arbitrable. So there's the concept of arbitrability. So there would still be, maybe this is what Dian, this is what you were referring to when you say there must be, it must be valid under the public policy of India. I would think that award would face some difficulties being enforced in India.
Can I just add something to this issue, Nick?
Okay, yeah, go on.
Okay, Kumar, so the point in Vidya Drolia, which is the Indian law now on oppression mismanagement, was slightly out of topic actually, because the Supreme Court was not really concerned with that question, but answered it nevertheless. And therefore went into the question of oppression mismanagement while it was answering the question of whether tenancy disputes are subject matter of arbitration or not. See, the difficulty with, I can't accept that judgment entirely, because in a shareholder dispute, there could be many disputes. There could be disputes with respect to specific performance, for instance, non-issuance of shares. Those are not oppression issues. Those are not mismanagement issues. Therefore, I think quite certainly you're looking at another set of judgments which are going to come on the extent to which Vidya Drolia will apply to cases of shareholder disputes, because it doesn't answer it entirely. It answers it, according to me, quite unsatisfactorily. It doesn't really answer the question as to what can be covered and what can't be. And therefore, Vidya Drolia, I think, is going to be we should actually have another webinar on Vidya Drolia itself. There is enough to talk on that.
I'm sure Shweta's taking notes, so we'll have governing law of the contract, although we might need another judgment on that, and arbitrability, both of which, you know, for those listening are important. You know, they're important freedoms given to party in choosing the governing law of their contract and where to seek their arbitration. But you also do need to have regard to where you're going to take your award to enforce it and whether there might be a reaction there. Well, let me bring Tom in on this question then of governing law, Tom, because I think it's helpful to hear both Dian and Nitesh and Shaneen on the question of governing law. From a foreign perspective, what governing laws do you see in contracts in relation to Indian business? And do you think that there's a hard choice to make there, or actually, you know, as a choice of Indian law, if it's not clear that you can choose a non-Indian law, is that the sort of thing that you see clients happily taking?
That's a great question. I suppose at the moment, clients who invest in India are very familiar with Indian law because for so many of their transactions, they've had to use Indian law in the past when arbitrating onshore. My overall impression is that choosing Indian law is much less of a concern than for them when thinking about sort of pricing their disputes and thinking about risk than having onshore arbitration. And we often get asked this during the negotiation process. You know, we're looking at trade-offs. We've got governing law and we have the seat of the arbitration. Which should I sort of stand firm on? And I think most clients consider the venue of the arbitration to be the more important issue than the governing law. Bearing in mind that at least in relation to sort of core contractual issues, interpretation, remedies, and so on, English law and Indian law have a lot in common with each other. So I think this is an important question for foreign parties, and I think completing the step away from India, as it were, by being able to choose a foreign law as well would give foreign investors more clarity and more familiarity with the investments they're making. But I think we've already taken the bigger of the steps by looking at the venue.
Yeah, thank you, Tom. And of course, we're all common law lawyers on this call, and all with a common root in terms of our legal tradition. So it's no great surprise that we feel relatively comfortable flipping between Singapore English law, Indian law, and certainly in my long engagement with the jurisdiction, I've never been too concerned about an agreement under Indian law. Of course, I need someone to explain to me what a contract act is and how that applies for us mere case law contract lawyers. Okay, let me go back to another point from the judgment, and I think I'd just like to clarify that for people listening, the two bites of the cherry point. Maybe Nitesh, could I turn to you just to explain for those who have perhaps read a report on this judgment what that means and what Justice Nariman was referring to when he said 2 bites at the cherry?
So that's an interesting observation, right? So what the Supreme Court meant, and I think it's absolutely clear, that when you have decided consciously to do arbitration outside India, you will have first the option to challenge the award before the court of the seat. That is one. Second is there will be a challenge when you enforce it under Section 48. So you will have to face with 2 challenges. First is at the court seat, and second is under 48. As compared to if you're doing arbitration in India, the only challenge is under 34, right? So there is only 1 challenge as compared to two challenges outside. That's what. But of course, I mean, it will all depend, which side you're representing, whether you want to resist a challenge or you simply just want to go and enforce the award, right? So that's what the Supreme Court meant.
Sure, thank you. I thought in some respect it was Justice Nariman sweetening the pill by saying, look, on the one hand, you might think I'm loosening the power of the Indian court in allowing parties to go overseas, but of course, you do get Indian court to scrutinize the awards when they're brought in to be challenged, including as a matter of public policy. And of course, public policy can incorporate mandatory law, whether or not you can contract out of Indian law, whether the court will allow you to do that. If you try and contract out of some element of Indian law, which Indian law considers to be mandatory, perhaps consumer protection or some other basic right granted under Indian law, then you may well find that even if you can choose Singapore law as the substantive law of the contract, there might still be some Indian mandatory law that bites. That, again, another interesting topic, perhaps one for another day. Just looking at a few of the questions, there's one. Yes, please.
Sorry, Nick, I just
Go
wanted
ahead.
to add something to that. I think this 2 bites of the cherry, I mean, even if the party succeeds ultimately in resisting enforcement, I'm not sure that situation is altogether satisfactory, because you still have an award made at the seat that has withstood a setting aside. You still have an award that is there that can be enforced outside of India. So as you say, perhaps, it's a subject for another day, but, having 2 bites at the cherry, while it sounds like, well, it's helpful for the party resisting the award, it may still lead to a fairly unsatisfactory situation. I just wanted to say that, Nick.
Sure, thank you. Good. Well, let's try and draw things to a bit of a close, I think, and go back to this question of fundamentally, do we like this judgment? Yes, we like the judgment as a judgment. Do we think it's good or bad for India as a seat of international arbitration? I can exclusively reveal the results of our poll, which are that 66% of you think that the decision is good for the future of India as a seat of international arbitration, and 34% thought it wasn't. So a pretty overwhelming result if this was a black or white issue. But I think also reflects that a third of you out there are not too sure about this being a good judgment. Let me throw this open to the Indian practitioners, and then we'll take the international perspective. Who wants to comment on whether they think this is a good decision for arbitration within India, and whether it will help to promote arbitration seated in India over the next few years?
Can I go first? I mean, so I had.
Nitesh, yes, you're off mute. Go for it.
Yeah.
Please.
So, okay, so I briefly, touched upon this when I was saying. So this judgment, as I said, the background is important, because what the court was considering is 2 Indian parties, can they arbitrate outside India, right? So this judgment should not be seen in the context that will it promote arbitration, India as a seat of arbitration, right? It should be seen as that it will promote India as the arbitration friendly jurisdiction. Because if the court is allowing, right, that the parties can do arbitration outside India, of course, it's bound to increase arbitration outside India. It becomes easy for parties to simply just go to SIAC Singapore, get an arbitration award, challenge, and then come under Part 2 and enforce it, because under Part 2 also courts, they do not interfere that much. So it becomes very, it's a good position as far as doing arbitration outside India is concerned. But I think we should just see this in a different there's a different perspective to this judgment, how we are adopting to the international principles, and even on the substantive law, right? What the court said, because that becomes very important. The court said that, yes, the conflict law principles, the part 2 under section 48 will already take care of situation if there is governing law, which is a foreign law. So I think we have to see in that context. That's how I see this judgment.
Great. Okay, thank you. Now we're going to wrap up now. Any short comments, Jan? You're off mute. Do you want to give us 30-second reaction on that?
On that question, Nick, my answer is it's actually neutral. I would actually ask for a third option of saying neither. I think it's going to take a few arbitrations outside India.
Yeah, well, we always,
and I'm sure
we always need third options. You don't always get them. Yeah. Tom?
Just very briefly, I think it is good for India as a seat, because looking at it for international parties, it's not just about the detail of the law, it's about sort of the overall direction of travel of the jurisdiction. And this is such a sort of clear indication of moving in the right direction. And Shaneen said it was done quickly, it was decisive. And those signals are important, as well as the detail of the law from time to time.
Nick, I just have a quick response. I don't think this, I think this is good for India as a jurisdiction and also as a seat, merely because parties are entitled to arbitrate in a foreign seat. I don't think there's going to be an exodus. There are some things going for India as a seat of arbitration. One of those is that a domestic award is automatically a decree of the court. There is no automatic stay. While you may have a challenge on patent illegality for purely domestic awards, by and large, courts are not countenancing unnecessary set-aside challenges. And you don't have to go through a two-tier process of challenging the award and then having to satisfy an Indian court again. Plus, if the award debtor wants a stay of the award, he has to deposit the amount in court, and the award holder is entitled to withdraw it. So there are a lot of reasons why you may still opt to have your seat in India, particularly if you're domestic entities. So I think this is going to be a very friendly decision for, say, foreign multinationals who maybe have a wholly owned subsidiary in India, and by virtue of that, they may want to have a foreign seat. But I don't think it might be completely logical for two Indian parties to simply go and arbitrate outside. But I think the confidence that parties get and foreign investors will get is that you've got robust, sophisticated courts that understand the concept of party autonomy, of public policy, and that is what will give you confidence in an Indian seat.
Wonderful, thank you, Shaneen. Kumar, I'm going to come to you for the last word. Obviously, SIAC is to a large extent agnostic. It supports India-related arbitration seated in India and seated in Singapore. But what's your view of this decision and India's future as a hub for arbitration?
I am with the 66%. I'm with Shaneen and Tom. It's the direction of travel that's important here. I think it gives investors into India, foreign parties doing business in India, a lot more confident. It makes India look more arbitration friendly and brings it closer to the approach taken in other established seats of jurisdiction like London and Geneva and Paris and Singapore. So I think on the whole, it would help India.
Great. Okay. Well, look, I think I share the positivity. I think the respect that this judgment shows towards arbitration, both inside India and outside India, the clarity which it brings to the analysis, and of course the of the bench itself is all arbitration and support for arbitration that is taking place outside its jurisdiction as well. Well, we're coming up to the end of time. Thank you to the panel for all the very interesting comments and for covering so much ground. Thank you for the questions from the viewers. Sorry we didn't get to all of them. We'll have a crack at answering a few now in writing, but thank you for throwing out such interesting points on this interesting decision. That's all for now. I'll pass back to Shweta if you want to say any final words. Otherwise, thank you very much, everybody.
Thank you, everyone, for joining in. And thank you, Nick, for exceptionally moderating this session. I personally enjoyed it very much. So thank you. Have a lovely weekend.
Thanks, everyone.
Thank you, everyone.
Thanks, everyone. Bye.
Bye.